Hi, welcome back to Finally Revealed. This episode is coming to you at the request of one of our viewers, and it centers on judgments. Had a couple of questions from people asking, well, I have a judgment against me. How do I get rid of it, or what do I do next? Now, I have another video talking about default judgments, but judgments are the culmination of a lawsuit. And in the context of somebody who says that you owe them money, a judgment is entered either because they filed the case and you were served but you didn't answer, or they filed the case and you did answer and you confessed, or they filed the case, you did answer, you had a trial, and the judge found that you did owe the money. And sometimes the judgment will be entered with your consent in connection with a settlement. Or another option might be they filed the case and you make arrangements for payment to them, but you don't enter into a formal settlement and you don't answer, and a judgment is entered in any event. Now, I had the question posed in a couple of these different areas, so I'm just going to try to cover them all. If there are additional questions after this, please leave them in the comments below, and be sure to subscribe to see our other videos. First of all, there are different kinds of courts, and there are different levels of courts. And some may or may not be a court of record, which then results in a judgment entered. The reason that people are most interested in a judgment being entered is because it can be enforced by the creditor, which means depending upon where you live, they can garnish your bank account, they can garnish your tax return, taxes are coming due, they can garnish your wages, they can attach non-exempt property and contact you by telephone and bother you to get this money. They can garnish other people who might be holding money for you, or if you are in a sole proprietorship business, they can go to your customers and try to get money that way. So it's better to deal with it up front before a judgment is entered, but sometimes things happen and now you have a judgment. So it's important to know what kind of court it is. If it's a magistrate court, a limited actions court, or an associate circuit court, and there are all kinds of other names for it, it might not be a court of record, meaning while they can enforce it, it doesn't show up on your credit report. So that's something to pay attention. If there's a judgment against you, do you have your credit report, and is the judgment on your credit report? So you need to know that. Now, in those limited jurisdiction types of cases, and that could even include small claims, there is usually a right to a trial de novo. That means you can appeal it and have the whole thing heard again. So if any of these other things I'm going to tell you won't work, or you're not having success with them, see if your judgment can be appealed in a trial de novo, and go ahead and get those papers filed. Usually you have a pretty big window of time to do it, so find out how long you have to do that and get that done. That will reopen the judgment. It won't be able to be executed upon, and if it is not something that's susceptible or eligible to be reported on your credit, it won't be, and that gives you some time. Now, like I said, the other thing is, if you are trying to settle and you consent to a judgment, understand if you are settling a lawsuit for money because you're going to pay it, and they say, well, we're going to go ahead and have a judgment entered, you go ahead and make the payments. Understand that while they should have a stay of execution, meaning you're going to voluntarily pay, so they're not going to run after you and collect the money, when you do pay either the full amount or an amount that you've agreed upon, make sure that judgment is marked as satisfied or released. And you should have any agreement for any such arrangement to be in writing, and actually it should be on the face of the judgment document that's filed, because that will give you some protection. And if the creditor is not cooperative, if it says right on the judgment the terms of the settlement and when it will be released, then you can apply to the court to have that released. Another way would be for a judgment to be written up but not filed. And that would also be in the context of a settlement. And that would be preferred for you, that it be eligible to be filed if you don't do what you say you're going to do, but it's not automatically done. So that's a little bit different, and if something is filed that shouldn't have been, then there is recourse. You go back to the court. And then if you have a judgment that was entered against you, whether you agreed to it, whether you blew it off, you didn't go to court, but it has been paid, then the judgment is not released, but it should be marked as satisfied. So you should contact the creditor and have them file a satisfaction of judgment. Now, the final way that a judgment can go away is by lapse of time. Depending upon where you live, a judgment lasts for a number of years. I think the smallest amount of time might be 5 years. So that's going to show up on your credit for 5 years. Again, unless it's satisfied, and then it will still show up, but it will show up that it was paid. And so if you are applying for other credit from another source and they see this judgment on there, but they see that you paid it, that may help you. So I hope this answered the questions. We're working on some exemption videos and some statute of limitations and some judgment time frame videos. So those, look for those. They should be coming out soon. If this helped you, give me a thumbs up. Like I said before, subscribe to see the other videos, and please come back and see me next time. Thanks for watching.